All right. Hello, everyone, and welcome to this webinar where we will talk about Nordic employment laws and give you a snapshot of a few areas of Nordic employment laws today. We have 30 minutes during this webinar, so it will be a quick exercise. We are 4 speakers today who will soon present themselves. And if there is time, we will deal with some questions, if you have someone, in the end of this webinar. But let's start with a presentation of the speakers.
Hello everyone, my name is Jonas Ingegaard. Nice to meet you. I'm a partner and head of deployment at the Skau Reiburt law firm in Copenhagen. We are a mid-sized law firm, but almost full-service law firm. I'm specialized in employment law. I've been doing that for the past 20 years.
Good afternoon, everybody. My name is Antti Reijamäki. I'm from Dottir law firm in Helsinki, Finland. We are also a mid-sized law firm, and I specialize also in employment law, been doing that for the past plus 15 years. Nice to meet you all.
Yes, my name is Håkon Andreasen, partner at Helme Law Firm in Oslo. Previously, we were called Storeng Bektu Lund, if anyone knows the reference. But Helme Law Firm, boutique law firm, work mainly with employment law and related areas of law. I've been here for 5 years and I'm working with employment law for 20 years. Yeah, nice to meet you.
All right, thank you very much, Jonas, Antti, and Håkon. So my name is Johan Sundberg, and I work at a law firm here in Stockholm called EDP Law. It's a boutique law firm working with employment law and also GDPR, the AI Act, the Data Act, and similar, digital or tech laws, one could say. All right, so we have 3 main subjects for today. We will talk briefly about selection rules in case of redundancy. We will talk briefly about termination due to personal reasons, as we call it. And then we will end up to talk a bit about some basic holiday rules in the respective countries. And we will start off to talk about Swedish redundancy rules and more precisely the selection rules under Swedish law. So to start with, redundancy is defined as every situation or reason for termination which is not referable to an employee in person. So, and that gives a wide range of situations where there could be redundancy. It could be a decrease of orders. It could be a restructuring or reorganization of the business, resulting in a reduction of workforce. There is no requirement that the business shall not make a profit or similar. So it's basically the employer who decides how to organize the business. Going into the selection rules, as you might know, in Sweden we have something called the last in, first out rule, the LIFO rule. Simply put, it means that the employee with the shortest employment period shall leave the company first in case there is a redundancy situation. In order to determine who is the last one in and consequently the first one to leave, you would have to establish a selection pool, turordning in Swedish. And the selection pool is normally established for each office or each factory or each workplace in the company. So let's say that you have an office at Kungsgatan here in Stockholm. That would be one selection pool as the main rule. If the company is bound by a collective bargaining agreement, the relevant unions could actually ask for a joint selection pool if there are more than one workplace or office in the same city. And the selection pool is based on employment period. So you would rank employees after employment period. If 2 or more employees have equal employment period, age will determine their position in the selection pool. where the oldest employee will be considered to have the longest employment in that regard. So the basic rule is the last one in, the first one out. However, in certain situations, it's not that easy. It could be that the redundancy is focused on one or more specific positions. And those specific positions might be occupied by employees who are not having the shortest employment period. In those situations, the employer would have to assess whether the employees holding the impacted positions have sufficient qualifications to be redeployed into another position in the same selection pool held by a colleague with shorter employment period. And if that is the case, it could be a bumping scenario where the employee holding the redundant position is redeployed to another position within the selection pool. There is also a possibility under Swedish law to protect up to 3 employees from termination. Basically, the employer has a freedom to choose which employees to protect, with the prerequisite that those employees are of special importance for the future business. Previously, it was possible to protect up to 2 employees if it was a small business with a maximum 10 employees. However, nowadays, under law, any business, irrespective of size, can protect up to 3 employees. I could also mention that if the company is bound by a collective bargaining agreement, there might be rules deviating from this in the collective bargaining agreement. So I think that was some basics for Sweden, and we will move over to the next country. So Norway and Håkon.
Yes, there we are. In Norway, all of this would mainly be regulated in the Working Environment Act, Chapter 15. So it's the Working Environment Act, Chapter 15, and also any applicable CBAs, if there is any. So that means that if you're bound by a CBA, that may involve different or deviating rules from the ones that I'm going through now. What you should know about Norway is that there are not very specific rules in the legislation, so you need to know the theories behind the rule of law and also case law. It's more the important thing, because mostly it's all about whether or not it all boils down to whether or not there is an objective justification for the redundancy and for the termination as such. Initially, there's no basic requirement that you are close to going bankrupt in order to have a redundancy scenario. You could basically have a redundancy scenario if you just decide that you'd like a larger profit. At least that's the initial take on everything. So you should have an analysis showing what reason you have for contemplating redundancies before you go through the consultations with the unions, etc. So in Norway, there is a requirement that you have justifiable or objective justifications for the terminations as such. That's regulated in section 15.7, so section 15.7 in the Working Environment Act. It only says that there may be a redundancy scenario, and that it must be objectively justified. But there's no specific selection rules as such in the legislation. So the employer has, I'd say, quite great freedom to choose which selection rule that should apply. But normally, what will be applied would be a mixture of seniority. How long have you been employed by the company? Combined with, which I think is natural, combined with an element of qualifications. Obviously, you can't compete for remaining positions if you're not qualified as such. But this is basically a question of whether or not you have the best qualifications. So you put together a table, a score perhaps, mixed between seniority, competencies, and social or personal circumstances, for instance. The selection rules or the selection criteria must be objectively justified. And obviously, the more objective they are and the less subjective they are, the easier they will be accepted by the courts. Seniority will always be objective, but there's no rule saying that you need to base your selection only on seniority. Quite on the contrary, the most normal thing would be to, as a default rule, to use competence and who has the best competence to stay with the remaining positions, and add in the seniority if there is significant differences between the employees in their seniority. But in that case, I would say, unless there's more than, say, 8 to 10 years difference between the employees in their seniority, that shouldn't be decisive. One important thing that deviates or is different from Sweden, which I think, so basically, LIFO is not a principle that's binding as such. There's a greater freedom in Norway to deviate from that than it is in Sweden, for instance. And also the selection rule is different. Selection pool, is different. You contemplate and you have to consider a potential bumping scenario, because obviously selection criteria is used for potential bumping. Someone could take someone else's place if they're better qualified and have longer seniority, for instance. It takes place within the whole business. That's the main rule. Within the whole business or within the whole legal entity. So if there is a company that has branches from north to south, east to west in Norway, you'd have to consider the selection and the selection pool to be, as a main rule, the whole business. Not the city, not the town, not the factory, not the premises. If you would like to reduce the scope of the selection pool and the redundancy, you'd have to go through the you'd have to decide that based on an analysis showing why this is fair and why this is objectively justified. And in that case, it would be very wise to use employee representatives to consult with them in order to show to the courts, for instance, later on, that this is fair and it has been contemplated, it has been agreed with the employee representatives. The unions as such do not play any significant role in Norway as it does in Sweden. But they do, obviously, if you're bound by a CBA. Yeah, I think that I have to do.
All right, thank you very much, Håkan. So then we will move over to Denmark, and I guess, Jonas, it's not too complicated in Denmark, is it?
It seems to be quite straightforward in Denmark. When it comes to the concept of redundancy, then the concept is in the Nordics. The codes examine the background for redundancy. Don't need to prove is necessary to terminate very limited. This means that you do them due to just the workforce to make more money, then that is fine. I don't know if you can still hear me. There was some problems with the connections. Now it's back. Well, the most important thing is that you do not hire a new employee in a similar position, because then it will be considered unfair. When it comes to choosing which employee to terminate, then there are no formal rules in Denmark that you have to follow. This means that the employer has a great freedom to access who they can best do without. Of course, there must be no arbitrariness, and a number of objective criteria are often applied when you decide who to terminate. That could be LIFO, but it's not a requirement, and within the public area you are not allowed to use LIFO, for instance. It could also be qualifications, but it could also be who sells the best, or who is most efficient, or who has least absence, better business understanding, etc. And as you can see, you will almost always be able to justify why you have chosen this particular employee. If they are protected, you have to be very careful. You have to be able to document that the selection is not due to, for instance, leave. That is why I recommend specifying which criteria and create a scheme where you for each employee against the criteria, and then select with score. This is absolutely if you have protected employees, but I do recommend under all circumstances, it's a very good thing to have that documentation if necessary. If you have a works council, it could be a good idea to involve the works council in determining the criteria to be used for the selections. As far as shop stewards are concerned, there often has to be compelling reasons, and there are special rules in the collective agreements regarding termination of shop stewards. And compelling reasons means that it's the last one to leave the premises within their area of work. Unions does not play a great role in relation to terminations, only if they believe it has not been done in the correct way. That's Denmark.
All right, thank you very much. And so finally then for Finland, Antti, a few words about the Finnish selection rules.
Yes, hello again, everybody. Basically, the redundancy situations are exactly the same as, for example, in Sweden. Basically, every situation in relation to termination, which is not referred to employee in person, can be considered to be like, a redundancy situation. And as mentioned by Johan, the redundancy situation can be formed in many scenarios. Basically, for example, based on a simple business decision, decrease of purchase orders, restructuring, or simply reduction in workforce. Obviously, the company and the employer, they hold the rights to make any kind of business decisions, and in redundancy situations, the most important thing from the Finnish part or the Finnish perspective is that the work of the terminated employee or employees must be diminished or reduced substantially and permanently. So that also defines the scope of employees who can be actually made redundant. Regarding the selection rules, there is no specific selection rule in the Finnish legislation. There is no last in, first out principle, for example. So it means that the employers have great freedom to choose who will be terminated, as long as the selection criteria is objective. So basically, in other words, you cannot select the terminated employee on discriminating grounds. For example, you can't choose that, okay, we need to terminate 2 out of 5 marketing persons, and let's simply select two oldest ones or 2 with the most sickness absences. That would be discriminating. But otherwise, the selection criteria is quite free. As some of you might know, we have around 170 generally applicable collective agreements in Finland, meaning in practice that 80-90% of the businesses are covered by some CBA in Finland. The CBAs might include so-called recommendations on the selection order, but they are not like legally bounding. So meaning that if the employer cannot follow the selection criteria defined in the CBA, it's not making the termination illegal. It's in the worst case, it will be only a breach of the CBA, which might lead to very minor fines for the employer, but it doesn't make the termination as such illegal. And maybe as a summary also, obviously, as mentioned, when terminating on redundancy reasons, you can terminate those employees whose work is actually reducing substantially and permanently. So you can also, meaning that also means that you can select the terminated employees only from that group whose work is actually diminishing substantially and permanently. So, for example, an easy example is that, okay, the company is planning to diminish or reduce workforce within the sales group, within the sales employees, meaning that we can't terminate anybody from the marketing department. The terminated employees will need to be selected from the sales department. But I think that's in brief the Finnish selection rules and regarding redundancy.
All right, thank you very much, Antti. So then we will move to the next subject, and I will take the lead on this. So we will talk a bit about the general principles regarding termination due to personal reasons. So that could be disloyalty, it could be poor performance and similar things. And we have some general principles which are quite the same across all the 4 countries. So the first thing is that there is protection in legislation. There could be protection in collective bargaining agreements and also in the individual employment agreement. Basically, across all 4 countries, the employer would need to have just cause or objective cause in order to terminate someone due to personal reasons. What is just cause or objective cause is for each country also established in case law. There are also some special rules. For example, in Sweden, if someone has turned 69 years old, just cause is no longer required. I can also mention that in Sweden nowadays, when you look at a problem with an individual employee, you would not make a forward-looking prognosis whether someone will improve, for example, or whether this will happen or not happen again. You would focus on what has actually happened in the individual case. In Finland, there is also a similar rule as in Sweden. So when the employee has reached a certain age, there is no longer a requirement for just cause. Same goes for Norway.
Next slide, Johan.
I think I would need to finish this slide first. So in Norway, the age is 72 years old when just cause is no longer required. And in Denmark, there is, on the contrary, if you have been with the company for a short period of time, there is no just cause required in order to terminate that employee. Poor performance was mentioned. It could be difficulties to cooperate with other colleagues. It could be disloyalty, a number of other reasons which qualify as personal reasons. What is also common between the 4 countries is that you would normally have to have a conversation with the employee about the issue. give them a verbal order or reprimand. You would normally have to provide a written warning also to the employee. And depending on what the issue is, the employee could have the right to help and support in order to improve. In some cases, it could also be a requirement to try to relocate the employee to another position in order to solve the issues. However, in certain cases, if the issues are very serious, it might be that the issues are so serious that they would justify termination with immediate effect. And in that case, you would not have to go through and have a conversation, a written warning, etc. So it's in all countries pretty much depending on how serious the issues and problems are. But I think to summarize, even if the principles are on a general level quite the same, there are different formal rules to follow in law and collective bargaining agreements. And I think it's also fair to say that Sweden and Norway stands out in the sense that it's a bit higher threshold in order to reach just cause or objective cause for termination, whilst in Denmark and Finland, the threshold is a bit lower. All right, we have a few minutes to go and we will end up this session to talk about basic holiday rights. And I will kick off for Sweden. So to start with, in Sweden, we have an earnings year where the employee earns his or her right to paid vacation, and that goes from 1st of April to 31st of March. The vacation year is the same period, the subsequent year, where the employee is supposed to take out his or her accrued paid vacation. That also goes between the same dates, so 1st of April and 31st of March. We have a main holiday period in Sweden reaching from 1st of June to 31st of August, where employees have a right to a certain number of weeks consecutive holiday. There is a minimum of 25 holiday days provided for in the Holiday Act. However, in many collective bargaining agreements and also in many individual employees, especially if employees have waived their right to overtime compensation, they are given 5 extra days, so in total 30 days per year. But the law sets out a minimum of 25 days per year. So Jonas, do you want to say something about Denmark?
Yes, I can do that. In Denmark, we had a new holiday act in 2022, introducing concurrent holiday, in Danish called samtidighedsferie. This means that you accrue and take the same year. So the year we qualify for holiday is from 1st September to 31st August, and the vacation year where you take your holiday is the September to 31st August, and then prolonged with a 4-month period until 1st December. May to 30, where the employee has 35, there's a right to take 3 weeks of concurrent holiday. In Denmark, we have 5 weeks of holiday each year, but most employees are entitled to 5 days extra, either according to collective agreement or according to individual agreement. So for most employees, it's 6 weeks per year. Yeah. Norway.
Yes, there we are. Thank you. Yeah, also, as we can see, the earnings year is different. It's from the 1st of January to, and it's a calendar year, as is the vacation year. The Holiday Act gives you 25 days a holiday, but that means 4 weeks and 1 day, because one holiday week or one working week in the Holidays Act is 6 days. So it's 6 times 4 plus 1. So 4 weeks and 1 day, that's the main rule. Collective bargaining agreements may include an extra week, normally, or 4 days, which makes it effectively 5 whole weeks of holiday. And my experience is that although that's based on the CBA or the CBAs, and that CBAs only apply to some businesses and not all, my experience is that most businesses actually apply 5 full weeks of holidays. The thing in Norway is that you have the right to full holiday, more or less, if you were employed sometime before September 2024, you'll be entitled to full holidays. But you only start accruing holiday pay for the next year. So basically, you can be entitled in Norway for full holidays for, the year that you start, but you don't accrue holiday pay. That will it will be unpaid holiday, because it's going to be you're accruing holiday pay for the next year's vacation. And this is a system that we use in Norway that may be in breach of EU's directives. So there is work going on in Norway. We're looking into changing this in order to conform with the EU directive, which I think is the reason behind Denmark's changes a couple of years ago, and we're contemplating do the same thing as in Denmark, but nothing is decided yet. Yeah, that's it.
All right, thanks. Antti.
Yes, so regarding Finland, the earnings year is basically the same as in Sweden, 1st of April until the last of March. You basically, in Finland, during the first earning year of your employment, you earn 2 holiday days per calendar month. And from the second earning year onwards, you earn 2.5 holiday days per calendar month. So in practice, basically, full holidays in Finland is 30 days, which equals to 5 weeks, because in Finland you consume 6 holiday days per week, Monday to Saturday. And the main holiday season is from 2nd of May until the last of September, during which you should basically use 24 days, equaling to 4 weeks, and then you use the remaining 6 days, equaling 1 week, during the winter holiday season, which is basically 1st of October until the last of April. And I think that's pretty much sums up it for Finland.
All right, thank you very much. So these were the slides that we had time to go through today. We thought that we would give an opportunity to highlight also that we will have a number of full-day courses during the spring, Employment Law 1, Employment Law 2 and 3, and also Nordic Employment Law News in the autumn. So, and those are really good courses and has been very popular for many years. All right, so there is also an evaluation that the tech team will send out, and very nice to see you all here, and thank you very much.